Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Maya, and Maya is going to tell us, about her practice. So, first of all, Maya, thanks so much for taking the time to join us. I know we got through a little power outage there, so we're good to go. And first of all, maybe you can tell me and my students and anyone listening a little bit about yourself and your practice of law.
Well, good evening, John Paul, and it's very nice to meet you. Thank you for inviting me to have this chat with you and your students. And I apologize for the technical issues that we had. That was totally unexpected. My name is Maya Shukairy. I'm a criminal defense lawyer. I'm a sole practitioner, and my practice is based in Ottawa, Ontario, in the East region. But I also do take cases outside of Ottawa. As I said, I'm a sole practitioner, and I've been a sole practitioner since I started my career as a defense lawyer. Before I started in defense, I actually articled in the Crown Office in Cornwall. I then worked for a short-term contract in the Crown's office, but then right away I just opened my practice as a defense lawyer in Ottawa, and have been doing criminal defense work ever since. And this is definitely the side of criminal law that is more suited for my personality and where I feel the most comfortable and that I enjoy doing the most, it being a criminal defense lawyer.
All right, so I will touch on that later, but let's get started maybe kind of like criminal 101, right? It's like, for a lot of the students I have, it's kind of the first couple of weeks, we're just learning about things like the charter, but maybe you can give us a nice overview of, you get that call, somebody is being picked up by the police, maybe one of your existing clients, and they're like, call my lawyer. So maybe you can kind of walk us through, that initial arrest. And then you can certainly stop piece by piece, and we'll follow up, but leading all the way up to, a trial and, potentially, if heaven forbid, there's a conviction, right, a sentencing there. So let's start with the arrest. Clients at the police station, you get the call. What's that like in talking to, clients in that situation?
Sure. So the first interaction a person will have with the criminal justice system is usually with the police. The police officers are the ones who lay charges, and they are the ones who will have the first interaction with the suspect and then eventually the accused. And during that time, police officers will, at first, they will investigate. They have a suspect in mind. They can interrogate. They can have investigation with the person, and then they will decide to lay charges, and then they arrest the person for the criminal offenses that the person is going to be charged with. And so once there are criminal charges that are laid, the question that comes into place, or the phase that we get into, is the bail phase. It's the determination whether or not that person who is charged with a criminal offense should be released or not. So the police officers can, in some cases, decide that the person is releasable, and that's typically when the person doesn't have a criminal history, it's their first time, it's a minor offense, or even if it's a little bit more serious, there isn't that much risk for the public. So the police feel comfortable releasing the person who has just been charged, and they will release them, of course, typically on an undertaking and with conditions that they have to respect, not to communicate with the people involved, and stay away from some people. But in cases that are more serious, where there is more concern for public safety, that individual will not be released by the police. Then there's another filter of discretion where it's the Crown can decide whether or not they can consent to the person's release. So the Crown will also look at whether it's okay. And of course, always on the police and Crown side, there's always this concern of public safety. So is it going to be concerning to public safety if we release that person? If the Crown doesn't consent to the release, then we get into bail, where that person has to be brought before a justice of the peace or a judge in order for their release to be determined, if they should be released or not. And at the bail stage, there are only 3 grounds, as your students may or may not know yet. There are only 3 grounds on which a person may be detained. and those are the primary, secondary, and tertiary grounds, and they are concerned with whether or not the person will show up to court, if they have a court appearance, whether their release will cause any kind of public safety concerns, and the tertiary ground has to do with the public perception and confidence in the administration of justice if that person is released, taking into account some factors that are listed in the primary ground that is in section 515, paragraph 10 of the criminal code. So bail is really more about this balance of should that person be released or not, and taking into account the three grounds, the three grounds of concern that I just mentioned for bail. And usually most bails are crown onus, meaning it is up to the crown to convince the justice of the peace or the judge why the person should be detained. But in some circumstances, it is what we call a reverse onus, where it is up to the person who is charged to convince the court and why that person should be released and not detained. And usually the reverse onus is in more serious cases, the gun cases. If the person is already out on release conditions and has breached, then it will be up to that person to convince the court why should they be released again, because if you've already been released and you've breached, then you've kind of missed your chance. You've already proven to the court that you're unable to respect your conditions. So now it is up to you to explain why you should be released. And usually from a defense perspective, when you want to have a client released on bail, you have to come up with what we call a bail plan in our practice, meaning that you have to find a way to convince the court that it is okay to release the person because you have a plan in place that will address all of the concerns that the court may have for bail. And one thing that I also have to mention regarding these grounds of concern at the bail level, in every case, you can have either one, two, or all three of these grounds of concerns. You don't have to have all of these concerns at the same time in one particular case. You could have maybe only the primary ground as a concern. Sometimes it's only the primary and secondary, and sometimes in the more serious cases, it's all of them. And then, of course, it becomes more difficult to come up with a plan or to convince the court that the person should be released. But at this stage of the criminal process, and again, here we're at the very early stage, the person has just been charged, and now it is up to determining whether that person should be released or not before their trial. If the person is not released, they will remain in detention, in custody, until they have their trial or until they decide they want to plead guilty. Now, I'm not going to get too much into that details, but there are also reviews, the 90-day review for the bail. Sometimes, you know, when a person is in detention for 90 days, then you can have what we call the bail review, 90-day bail review, and reevaluate why that person should still remain in custody. But then, assuming that the person was released, and in most cases, the person should be released, because we have to remember that the underlying a principle in criminal law is the presumption of innocence, that the person, even if they are charged, even if it looks like the evidence against them is strong, they are still at this stage, still innocent until they are proven guilty at a trial, or until they decide that they want, or until they plead guilty and take responsibility for what happened. But until that happens, they are still presumed innocent. So they should be released in most cases. Once that person is released, then you get into the phase where we call it the disclosure phase. As from the defense perspective, well, now the accused wants to know, well, what is the evidence against me? On what basis am I being charged? At the beginning, when the person is charged by the police, they have some idea about what the case is about. They certainly know what the charges are against them, but they don't necessarily have all the information that's against them. They have the police may disclose some or not that much of that information that they have. But then after the bail stage, that's when they will start to receive disclosure. And disclosure is basically all the evidence, the reports, investigative actions, notes, witness statements, physical evidence, or whatever. Like it could be a variety of different types of evidence that they can receive from the Crown. And that's when they will have to go through the process of looking at this evidence and disclosure that the Crown has against them and understand what the case against them is and how they're going to defend themselves. Once you have disclosure, you can also request additional disclosure. If, as a defense lawyer, you're reading the case and you realize that there are some elements that are missing, you request additional disclosure that the Crown has to give you if they have it, if they are in the Crown's possession. And on the topic of disclosure, another underlying principle is that the Crown has an obligation under the case of Steenschroon to disclose everything in their possession that is relevant to the case and that is not privileged. So they really have to give the defense everything that they have and that is in their power. There are sometimes, however, situations where the defense may request some disclosure that the Crown doesn't have, and this is when we have what we call third-party disclosure, disclosure application. So when we're requesting elements that the Crown is not in the possession of the Crown, and so we will have to ask the court for permission to obtain that disclosure. And of course, the underlying principle is that it has to be relevant. The type of evidence in this case that I'm talking about is commonly, it could be medical reports, psychiatric reports, school reports. So it's evidence that is usually in the possession of third parties, of hospitals, a psychiatric institution, or a school. And so for that, there's a special procedure, which is the third-party application. And it gets even more complicated when we get into sexual assault cases, because these cases have become even more complex now. So once you get into disclosure, you review all the disclosure that you have from the defense perspective. You request the additional disclosure. You think you have third-party applications, then you're going to have to make those applications as well. Then what we can have also in some cases is what we call a preliminary inquiry. Now, a preliminary inquiry is a lot less common now than it used to be, because recently there have been changes to the law, and a preliminary inquiry is only an option in cases where the charges, where the accused is facing a charge that is punishable by 14 years in prison or more. If none of the charges that the accused is facing is punishable by 14 years or more, then there is no preliminary inquiry. And a preliminary inquiry is, from a defense perspective, a way for the defense to see for the first time the Crown's case, to test the strength of the Crown case, to get to hear from some of the witnesses. It is also an opportunity for a defense lawyer to create some inconsistencies in a witness's statement, because you're going to be hearing for the first time from a witness very early on in the process, and you're going to hear from that witness later on at trial if the matter proceeds to trial. And if there are some inconsistencies between the statements of the witness at the preliminary inquiry and at the trial, then this is a good opportunity for defense to show some inconsistencies and put into question the reliability or credibility of the witness. So it is a first maybe we can say a preview of the Crown case. So this is the first opportunity for the defense to see what the Crown case is like, to see how strong it is. It is also a way to see if committal is an issue, because sometimes this is when the weaknesses of the Crown cases are also revealed. And sometimes if the case is not really that strong, if the witnesses turn out to be unreliable and not credible enough, then this is also an opportunity for the Crown to reassess their case and to determine whether or not they want to take this matter to trial, or if they want to resolve it at that point. So we have that preliminary inquiry process that happens. In some cases, like I said, it's not an option in all of the criminal cases. But then after that, there are also what we could have in some cases is what we call the whole mental health aspect. Sometimes in cases where an accused for example, has mental health issues, and those mental health issues have an impact on the accused's fitness to stand trial, or if there is also an issue regarding their capacity, or what we call criminal responsibility at the time they committed the offense, we also have to assess that. So I'll briefly talk about that, because mental health is really an area on its own. Like, it is related to criminal, it is part of the criminal process, but it is really a very niche area. But it is very important also from a defense perspective that if there are concerns as to the mental health of a client, to really determine whether the client is fit to stand trial, is fit and able to provide instructions to counsel and understand what the criminal process is about, or if there are some issues regarding their criminal responsibility. And these two elements, fitness and criminal responsibility, happen or have to do with different times of the process. Criminal responsibility has to do with the accused's mental state at the time the crime was committed. So here we're looking at the moment when the crime was committed. Did that person have a mental disorder that rendered them unable to determine right from wrong and to understand the nature of their act? So it really has to do with that moment in time, at the time the act was committed. Was that person affected by the mental disorder to the point that they were not able to determine right from wrong? And the fact that an accused person has a mental disorder does not necessarily mean that they are not criminally responsible. That mental disorder has to affect them to the point that they are unable to decide right from wrong or know what they're doing, the nature of their act. Fitness to stand trial has to do with their ability to provide instructions to counsel, and the threshold is low. There have been some recent changes with a recent case from the Ontario Court of Appeal, Barwani, but it has to do with their ability to understand, like what the role of a prosecutor is, the role of defense counsel, the role of a judge. And so this is also something that has to be assessed, because it will have an impact on the way the proceeding will happen. So if then, so you have the disclosure, let's say you have the prelim, then there has to be, like, the most important decision that an accused has to make in a criminal matter is to decide whether or not they want to plead guilty, or if they want to fight the charges and have a trial. And this is a decision that really belongs to the accused. The lawyer's job here is to guide the client. And here, the lawyer, of course, I mean the criminal defense lawyer, not the Crown, because the Crown doesn't have clients. The Crown is only concerned with the public interest and is prosecuting, whereas a criminal defense lawyer represents the client, and it is the criminal defense lawyer's job to represent the best interest of their clients. But even if your job as a criminal defense lawyer is to represent the best interest of your clients, there are some decisions that really have to come from the client. And one such decision is whether the client wants to plead guilty or have a trial. The lawyer can certainly give advice, give recommendations, but ultimately it will be up to the client to decide if they want to take responsibility and plead guilty and waive their right to a trial, or have a trial and not plead guilty. And if, of course, the accused decides that he or she wants to plead guilty, then there won't be a trial. And so we'll just go right into sentencing. And sentencing is the determination of the appropriate penalty or sentence that should be imposed on the accused. And of course, it takes into account several factors like proportionality, parity, and it really, sentencing is a very individualized exercise that has to look and take into account the specific circumstances of the offender, the circumstances in which the offense happened, the gravity of the offense, the seriousness of the case. And so it is really it's a balancing exercise, sentencing. But the role of defense counsel is really to to give as much background information about their clients and to explain what led the client to act the way they did, and explain all the mitigating circumstances that could justify and explain why this happened. If the client doesn't want to plead guilty, so we won't go into sentencing, we'll go to trial. And trial really is where the determination as to whether the person is guilty or not happens, either with a judge alone or with a judge and jury. And in Canada, we have two forums. It's either in the Ontario Court of Justice that we can have a trial, or in the Superior Court of Justice. If it is a jury trial, then it's going to be at the Superior Court. And of course, there are some other distinctions as well. It's depending on whether the Crown is proceeding summarily or by indictment. So summarily is usually the lighter way of proceeding that allows the Crown to go for a lighter sentence, whereas a proceeding by indictment is the heavier way that allows the Crown to ask for a harsher sentence. So if we go then to a trial, then this is where the determination of guilt or innocence takes place. And this is where the trier of fact, whether it's a judge alone or a judge or jury, will hear from the witnesses. Sometimes the accused will testify. Sometimes the accused will decide not to testify. That also is a decision that belongs to the accused, whether or not to testify. The accused has the right to remain silent throughout the whole proceeding. This is a constitutional right where they don't have to say anything, and they can just let the Crown prove the case against them. But then it will be up to the trier of fact to determine whether the accused is guilty or not. If they're acquitted, then they're free to go, and they don't have to deal with sentencing. If they are convicted, unfortunately, that's when we get also into sentencing, and then the judge will determine what the appropriate sentence will be in that particular case, of course, with the same principles that will apply, parity, proportionality, and all the other sentencing principles. And sometimes there could be some reasons to believe that this decision that was taken, whether it's the conviction or the sentencing decision, wasn't the right decision. And that's when we can go to an appeal. That could be a second step, another step. But it's an appeal is not based only on the fact that one of the parties is not happy with the decision. There have to be some grounds, whether it's a factual error or a ground, or it's mixed facts and law, or it could be for a legal reason. It could be so different reasons. The judge did not apply the proper test, or did not apply the law properly to the case, or there wasn't or the judge didn't take into account parts of the evidence, some important parts, or misapprehended the evidence. So there has to be some specific reasons or grounds of appeal to go into an appeal. But then we have the appeal. This is then the next phase. If at the first instance we sense that there's something that didn't go well, then we can go to the appeal. And that's usually like a very big summary of the criminal process from beginning to end.
Perfect. Thanks for that. It's an excellent overview there. A couple of things, I guess, to follow up on, especially in the news now, and you were talking about this presumption of innocence. And I don't know, I feel like I see on Twitter and in the listserv, all of these criminal defense lawyers kind of want to pull out their hair, where people are talking about the bail reform and, strengthening bail. And, people forget that we have a presumption of innocence no matter what. You're presumed innocent until proven guilty. And so what are your thoughts, when you hear about all the, especially in the media, about, when someone is arrested, they're tried and convicted in the court of public opinion, and now people are saying, well, we need to toughen up bail, and we're going to devote resources and change laws. Now, how would you respond to that, being, on the criminal defense side, where people are so quick to throw, your client behind bars and say, you're going to be found guilty anyway, so might as well be there for now rather than later?
Yeah, and this is a really good point, because it is probably one of the most frustrating things that defense lawyers have to deal with. It is trying to protect the presumption of innocence of their clients, because, even in cases where it might appear like the evidence is strong, honestly, you never know until that evidence gets tested at trial. I mean, that's why we have trials, because that's when you get to see the evidence and how strong it is against your client. And when these witnesses who make statements and allegations about accused persons get tested in cross-examination, sometimes you realize that, like, there are a lot of problems in their statements and in what they said and in their evidence. And it turns out that their case is not, the Crown's case is not as strong as it appeared to be at the beginning. The presumption of innocence is really very important, because I mean, we all know that there have been some wrongful convictions. I mean, this is not a surprise. A lot of people have been wrongfully convicted throughout history and for different reasons. I mean, recently we've seen how one pathologist has had several cases of wrongful convictions that were only revealed several years after the lives of so many people have been affected in a very bad way. And it's very unfortunate, because as a criminal defense lawyer, I get to see with my clients how it affects them, how simply being charged with a criminal offense. I don't think that people realize how much of an impact a criminal charge can have on the life of a person. They don't realize until it's them, they are accused, or someone very close to them is facing a criminal offense and they have to deal with that. It will have an impact on almost all levels of their lives. It impacts their work. People can lose their jobs right away for certain sensitive types of jobs or vulnerable sector types of jobs, or jobs where you have to have a license and it gets updated and you have to renew your license and they have to do a background check. And when they see that there are criminal charges against that person, then could cause some issues in the renewal of their license. So it will have an impact on their jobs. It will have an impact on employment, on travel. A lot of countries will give you a hard time. We know if you want to travel to the US and you have a criminal record, it's very difficult. It's very complicated. It will have also, sometimes people don't even know that even if you want to volunteer, sometimes for volunteering, they do some background checks and they won't let you volunteer if you have a criminal record. So it has an impact on a lot of aspects of a person's life. And there's the stigma that comes with being charged with a criminal offense. And it's really very frustrating to see, we see our clients, the difficulties they have to go through. You as a criminal lawyer, when you hear, because we're always bound by solicitor-client privilege, so we always get to hear a lot more about the case than what eventually gets out there in a trial or during the proceedings. And when we know what really happened and what's going on, and we know we can't talk about it, we can only start to expose that information at trial, it becomes, or, as the process, because sometimes you have to reveal throughout, like even before trial, like through your theory of the case, you will show what the defense is going to be. But I mean, you know what happened. You get to, as a defense lawyer, I think you get the closest to what really happened through your communication with your clients. And when you hear the story, you realize that, like, there's a lot more than what the media knows and what's being portrayed out there. And it's just unfair to judge a case and a person without hearing both sides. And it's really not until we get to trial that we really get to hear from both sides. Before that, you're really hearing from one side, because on the defense side, you're always trying to protect your case, your defense, as much as possible. The accused will remain silent. Of course, some individuals choose to speak and they're loud and they'll talk about their case, but most lawyers will usually advise their clients not to say anything and to remain silent. So you're only hearing from one side, which is the other side, the complainant side, who are just saying, oh, this guy did that to me or whatever. And then you're judging a whole case based on one side. And that is not the fair way to decide a case, because at a trial, you have to hear from both sides. You don't present only the complainant side when you go to trial. The judge has to hear the other side of the story. And it's after hearing all of the evidence that the determination of guilt will be made. And unfortunately, what we see when a case, especially in high profile cases where we get to hear a lot about the case even before we get to see the evidence, we're only judging a case based on one side of the story. We haven't even heard what the defense is, or what if the defense also has evidence to present on this case. So it's unfair, and it's frustrating, and I really hope that there could be more education on the presumption of innocence and on the importance of the presumption of innocence. And I would say that I really hope that people won't right away jump to conclusions just based on what they see, the results of the criminal act, because you still need to prove how this happened, why this happened, and who did that, before you can really give a good and fair judgment about the case.
Now, another of the steps there, kind of after the bail hearing, after the disclosure, is, looking at resolution, right? You were talking about potentially, the instructions from client of pleading guilty. So you have those discussions, in a Crown pretrial, or, even a judicial pretrial. So maybe you can tell us a little bit about kind of preparing for those steps in the event, it may not go any further in terms of a resolution, or even if it is going to go, and we're going to set the matter down for trial. Kind of what goes in preparation for those points in the process.
Yeah, I mean, for resolution, it's also ultimately a decision that the client has to make. I mean, the client has to decide whether or not they want to take responsibility and plead guilty, or if they still want to fight the charges. And there are also some factors that come into play. I mean, like, the strength of the Crown case is definitely a factor. I mean, if the case is really very strong, and let's say the Crown is offering a good resolution deal, how we call it in criminal defense. So sometimes the Crown will offer a good deal that if the client is prepared to take responsibility, then they can, look at all the mitigating factors. And if the client is prepared to do some upfront work, then they will, certainly change their position. So that decision, it really has to do, it's very case to case specific. I would say. I mean, there's no general rule as to how, when a person should resolve a case or not, but you have to have discussions with your client. You have to inform your client of the Crown position, of the things or the upfront work that the Crown is looking for in order to change their position, because sometimes the Crown will offer a resolution. In every case, they will offer a resolution. Even if it's a case that is likely to go to trial, the Crown will say, okay, if you want to resolve the case, this is our position. But sometimes, and in many cases, the Crown's position is flexible. This is their position now, before even hearing any information about the accused or seeing what type of work the accused is prepared to do. Sometimes the Crown will take into account some background information about the accused. Definitely, if there is a racial background, ethnic background, some strong and mitigating factors as to the past experiences of the client. If it's someone who has experienced a lot of trauma, who is a victim of abuse, for example, and now they're abusing someone, I mean, that could, be a factor that the Crown is willing to take into account. If there are mental health concerns as well, this is also a mitigating factor, because you can't treat a person who's mentally ill the same way you treat a person who's perfectly sane, who knows what they're doing, and who doesn't have any mental disorder that is affecting their ability to make judgments in the situation. So there are a number of factors that have to do with the accused, the circumstances of the case, and what the accused is prepared to do to take account and take responsibility for their act. So that could also have an influence on the Crown's position. But of course, there are some cases that are way too serious that, I mean, it's very hard to have a better deal. So again, it really depends on the case, but it is the interesting part here is all negotiation. This is the phase where it's all negotiations between the defense lawyer and the Crown, negotiations with the clients, discussions, you talk with the client, you explain the case, you explain the information that you're receiving, and then ultimately it will be up to the client to decide what they want to do.
Now, one last piece there in the process there, and because we were talking about it today in class, was related to the charter, right? And sometimes, your client might tell you, hey, I did it. However, there may be, some kind of charter issue, a police didn't follow some kind of procedure, a trial delay. So maybe you could kind of give us a quick, I don't know if there's like a recent charter argument that you raised successfully or something, but, just give an example of how the charter can change the course of an outcome of a trial where, factually maybe nothing really, strong evidence to the contrary, but there is an issue, where the charter may be involved that you got to raise for your client.
And we see that a lot in impaired driving cases and drug cases. Like those are the cases where even if, let's say, factually, you find like, okay, like it's there was impaired driving, but that's when we get into charter issues. So this is where, okay, fine, like the client may have had an blood alcohol level that was really high, but then the whole issue is, well, but what happened before that with the police interaction? And the charter is really, it applies between states and individuals. Like you can't talk about the charter. There's no application of the charter if it's between individuals. Like if it's only between civilians, then we're not talking about the charter. The charter only comes into play when it's a state actor acting and infringes upon the rights of an individual. So there has to be some problem with the police interaction for us to invoke the charter. Otherwise, we can't talk about the charter. Like if it's a problem between the complainant and the accused, you can't raise the charter. Like you can't say, oh, the complainant breached my right to silence. It's not a complainant who's going to breach the right to silence of a person. It's a police officer, a state actor, or state agent. So that comes into play when there are problems with the police interaction. And like I said, most commonly in impaired driving cases or drug cases. And it is a test of how did the police do their job to get their evidence or to get the information about the accused. Because, we allow the police to do their job, but they also have to do it in a way that they don't violate our rights to the extent that this is, of course, acceptable, because some violations and some breaches will still be accepted. There are exceptions, not because there is a breach of a charter right that there is automatically an exclusion of the evidence that is found. Some of them will be permitted, and that will be all the analysis that is done under Section 24.2 of the charter. But the important question here, and the whole philosophy of the charter, is did the police do their jobs the right way? Did they respect the individual's rights while they were doing their investigation, while they arrested the person, when they detained the person? And the legal rights that are commonly invoked in a criminal context are the ones in section 7 to 14 of the charter. So those are the legal rights that we commonly talk about in a criminal context. And it has to do with the person's right to silence, their right to have a lawyer, to retain a lawyer, their right to their rights upon arrest and detention. And it is really this whole police interaction and how the police did their job. Did they violate the rights? To what extent? Is it an acceptable violation of rights or not? And so sometimes a case can be won, even if, like in an impaired case, even if the blood alcohol level is really high, if the way the police did their job really infringed on the person's right, like, for example, the arrest was illegal, the detention was illegal, then the evidence will not be admitted. In that case, it's the alcohol levels that were then obtained, then the case will be thrown out, even if the case is very strong. Another way also, you can, in a criminal case where you can also, even though you have a strong Crown case, but where the case can still be stayed, is if we're talking about 11B. So if it takes way too long for a case to get to trial, and when we do the calculations and we account for who is responsible for the delays, if then it turns out that it is outside of the range that is allowed by Jordan, the case of Jordan, which has established these new delay rules, then that's also another situation where, even though there may be a strong Crown case, but it will be thrown out because of unreasonable delay in having a trial.
Now I want to circle back there, and thanks, Sarah, for that thorough overview of everything. Kind of a criminal 101. I wanted to
Yeah.
circle back because you had mentioned at the very beginning that you had some time working on the Crown side, and now you're doing defense work, and certainly anyone that's interested in criminal law. I mean, those are the main choices you have if certainly obviously want to practice. So maybe can you tell us kind of what's the difference in terms of having that role as a Crown, and now you said I much prefer being on the defense side, and kind of what the thought process, in having that opportunity on both sides, why you kind of made your decision to what you're doing right now, and any guidance you have for anyone that's interested in criminal law and looking to decide between, where to work.
So I would say that my answer is really based on my own personal experience. I can't tell anyone what they can or should do, and it's definitely not a recommendation that I'm making for people. I'm just sharing my personal experience. Defense is what I find is suited for my personality, for who I am, for what I stand for, what I appreciate in life. I did do Crown work because I had that opportunity and I wanted to do it just because I realized that it's better to make a decision once you've experienced the other side. I mean, at least I know what it's like to work in a Crown office. I've been there, I've seen it, and it is interesting work. It's still criminal law, but it's a different side of the criminal case. I really enjoy doing defense work a lot more than I enjoy doing Crown work. Defense is very different because, first of all, as a defense lawyer, you have a client. When you're a Crown, you're not representing a client, you're representing the public interest. So you're not getting instructions from clients, you're not building your case with a client. A lot of people sometimes mistakenly believe or think that the Crown is the complainant's lawyer, but that's not true. The Crown is not the complainant's lawyer. The complainant's interests are part of the public interest, but the Crown does not represent the complainant. And sometimes, like we're seeing now in sexual assault cases, complainants can have their own lawyers who can also have standing in a criminal matter. But a defense lawyer has a client. You have to represent the interests of the client. What I like about being a defense lawyer is that I really get to hear a lot more about the story from speaking to my client. I mean, sometimes I get to know more about the case, some things that the Crown will never get to know about, because I just get that opportunity to speak to my client who is actually part of the story. It's also having to poke holes in the Crown's case. The job of the Crown here is to prosecute. They take the case, they take the evidence that has been gathered by the police during their investigation, they put the case together, and then it's based on that case that they will prosecute the accused or the defense's client. A defense lawyer's job here is to look at this Crown case, analyze it, and see how strong it is, look for the weaknesses, look for the possible defenses, and poke holes in that case. So you're always trying to show that, no, this is not, like what the Crown is trying to show is not true, or it's wrong, or there are problems here, there are issues there. So it's really trying to poke holes in the Crown's case that I also find a very interesting exercise. So that's the challenge with every case that I get. It's like, okay, where's the problem here? Where can I show? Where are the weaknesses? And sometimes there are no weaknesses. And sometimes there are, and those are the better cases when you can right away tell, okay, no, the Crown has a problem here, and that's why you have to just, find a way to get the best outcome possible for your client. And I mean, ultimately, where you want to end up working is up to the person's own personality. Being a defense lawyer is, I find, having done a little bit of both, they're challenging in different ways. I would say when you're a Crown, there's a lot of volume work. You always have all these cases that come through your office and it never ends. So it's a lot of volume work. You don't really have that much time to prepare, especially if you're not a senior Crown. I think senior Crowns have more time they have less cases to focus on. They take the more major cases, or they focus on specific cases, so they have more time to prepare. But you have less time to prepare for your cases when you're a Crown. Defense, you have more time, also depending on the volume of your practice. I mean, of course, the more experience you have, the more cases you have, the more challenging it becomes to prepare for each cases. But you still have, I think, more time to prepare than Crowns, and you should be more prepared as a defense lawyer because you're representing someone's life and liberty. So there's more responsibility there to be even more prepared, I think.
Now, a question that came up, and I think you're
Okay.
probably one of the best to answer, came up in my class. When their students were doing their introductions, and they were saying a little bit about themselves, and one of the students, she said, I've always been really interested in criminal defense work, but in my country, it's dangerous, for women to be working in criminal defense, and I don't know. I mean, I guess now this may be a good segue to talking about Wicked as well. I mean, I know there's great work there, and so what do you find in terms of working in criminal law and in what you're doing, and any guidance there for someone now that's coming over to Canada and they want to do this? Should they have that same apprehension as they had in their home country?
So, I mean, I don't know what the home country is, and I can't obviously speak to that experience. I would say, as to safety concerns, are there safety concerns? I think in any job there is going to be a safety concern, not just in criminal. I mean, I just find lawyers in general, just the fact that it is an adversarial system, you're going to have people on the other side, or people in the public who just don't like your role, don't like what you're doing, and they're just going to be expressing that in a scary way. Now, maybe the concern here in the practice of criminal, as a female defense lawyer, when you're dealing with someone who is a criminal, because that's how people view them, that our clients are all criminals. Am I afraid of them? No, I'm not afraid, because many of them, of course, some of them maybe are guilty technically, but many of them are not. And I mean, what people don't realize is that these people are just normal people. They're just like people like you and I. Like, they are normal people who just got into bad situations, or situations where they made bad decisions, they got into trouble, and sometimes, in some cases, they're not even they're not even guilty. Like, they were, some people do report to the police when it's nothing really happened. It's just because, for whatever reasons, they just don't like that person, they out of revenge, or because whatever reasons they had. So many of my clients are not even dangerous at all. Like, I have absolutely no safety concerns when I'm with them. Now, there could be cases where there could be a little bit of more of a concern, especially if a person is mentally ill. But honestly, I mean, I on a personal level, I've always had very good relationships with my clients. I'm not afraid of them. I just have a good connection with them, a lot of trust that I build with my clients. And honestly, it is my job to protect them, to defend them. So I find it's something that you have to develop also with time. It's a bit more difficult at the beginning. I mean, it is a question that I had at the beginning when I started practicing criminal defense, that, well, what if I get someone who's dangerous? But the more you get exposed to clients, you get to meet them, and you realize they're all normal people. They're normal people. And many of them, they will have that trust. They will build that trust with you as a lawyer, and they want you to protect them. So they're not going to harm you. They're not going to hurt you. They want you, they look at you as their savior, and that you're the one who's going to get them out of this bad situation that they got into, whether it's because they put themselves in there, or it's because circumstances made them get involved in that situation. So I can say that here in Canada, I am not really concerned. And I mean, I have a lot of female defense lawyer colleagues here. We do the same thing, and we don't really have that concern. And if it does happen with some clients where there are some concerns, like usually you can always make sure that, if you're not working on your own, you're working in an office, that you're having that meeting with that client that you're afraid of, knowing that there's someone in the office with you, that you're not alone one-on-one on a client if there is that concern. And even if you're alone, you can always have other ways to meet with the client. I mean, I can say that once I had a meeting with one client that I was just a little bit concerned about because of mental health issues. And, I just met with them in the courthouse, like in the courthouse before COVID, we had some rooms, private rooms for counsel to meet with their clients. And there, like at least I know that if something happens, I'm in a courthouse, there are other people around. So I can just go out and, ask for help. There are police officers in the courthouse. So there are always ways that you can make sure that you're not completely alone. But really, you're not going to, like, the majority of your clients are not going to be dangerous.
Now, I mean, the other question that I guess criminal defense lawyers also get a lot of times is kind of that version of, how do you sleep at night knowing you're representing people who may have committed these crimes, and you're kind of finding ways to, get them out onto the street? So I know we've talked about obviously the presumption of innocence, and just talked about the fact that factually your clients may not have done it either. In a lot of cases, there's false reports or people go forward, or false allegations, things like that. So, I mean, what is your response to that? I'm sure you get that question all the time. And, again, there's a lot of, we were talking about the media before. Some people are like, we don't want even these criminal defense counsel to speak to our students at school because they're representing people that are charged with sexual assault. So what are they doing here talking to our students? So how would you kind of respond to that sort of sentiment there that seems to be in the media and in society about the work that you do as a criminal defense lawyer?
Yeah, I mean, like it really, for me, it goes back again to the presumption of innocence. I just find like this is a very, those comments, when they're made, it's really disregarding the presumption of innocence, and there isn't this appreciation of how important it is, because until that person is proven guilty, they are still presumed to be innocent. And I defend them because I believe that, that they are innocent, or that they should be, even if they're not innocent, that they still should be treated in the right and proper way. And it is actually more difficult when the person is actually innocent, and you have to protect them and you have to get the best outcome for them, because it's this whole presumption of innocence is extremely important. And when you know that someone is innocent, and you see that through the case and through what the person says, then that's when it becomes more difficult to sleep at night, because you want to make your best. And this is actually one very famous American criminal defense lawyer, Mark Garrigus, whom I interviewed recently in one of my series, Who Cares? That's one of the things that he says. It's like, it's when I know that my client is innocent that I can't sleep at night, because I have to defend them and make sure that they don't get stuck in this criminal process. So no, I mean, I sleep well. I don't sleep well when I'm really concerned about the outcome of the case, and I really want to get the best outcome for my client. But because I'm defending that person, no, I mean, that person is presumed innocent. It's a person, and a perfectly normal and ordinary individual. And that, again, is something that really I find is so frustrating, is that right away people treat people who are charged with a crime, unfortunately, like they become a new category of people, like those people who are charged with crimes. And they're just ordinary people. Like, just before the moment they were charged with a crime, they were, just like anybody else. So you don't become a different type of human being because you're charged with a crime. And just wait until you hear the evidence at trial and see, and then decide if that person is the monster you think he is, and make your judgment then.
Now we touched on a couple of things there just before, and I think maybe I want to make sure you get enough chance to explain, the all these amazing things that you're in, and congratulations on the recent award you received as well. So tell us about Wicked. And people are like, what is he talking about? Wicked? What is that? The
Stand for.
acronym. And again, we were just addressing, women in criminal defense and making sure you have support and mentorship. So first, maybe tell us about Wicked, and then tell us about, the Find Your Niche and, all the other work you're doing in that organization. And again, I think it's amazing work, and highlight all of the stuff that's there, and the resources that are available for people that are getting into criminal law. So I'll turn it over there to you to address that.
Well, thank you very much. And Wicked, as you mentioned, it is it's an acronym for a new association. It's been a little bit over a year now that it exists, and it's called Women in Canadian Criminal Defense. It's a national association, a free, not-for-profit association. Any female or female identifying criminal defense lawyer can join Wicked. We also have student members. We also have articling students. We might open it up to other groups as well, but it has to be on the defense side. So we have some duty counsel who are member as well of Wicked, but no crowns. It's really for the defense. And really the main force behind Wicked is Anita Zigeti, as you know. And the reason why Wicked came into existence was because of all the issues that we recently realized female defense lawyers were facing in the practice of criminal defense, unfortunately, and that really got even more of a problem during and after the pandemic. We've noticed that a lot of female lawyers get into the practice of criminal law, but unfortunately, many of them leave and don't. Either they go to the Crown side, or they just leave the practice of criminal law altogether. We also noticed that there was a lot of differences in the treatment between female criminal defense lawyers and male lawyers. That female criminal defense lawyers tend to be yelled at a lot more in court. They tend to be like they receive more negative comments. There's sometimes this presumption that they don't really know what they're doing. They routinely get mistaken for being everything but the lawyer. They get mistaken for the interpreter, the student, the articling student, but then nobody really wants to or think that they are the lawyer until they say, no, I am counsel for X and X client. So it's all these issues and the problems also in finding employment. I mean, that's a general problem. It's not just for female defense lawyers, but I mean, like, it has been affecting a lot of female defense lawyers. So all these issues that we notice have pushed us to want to create an association that is really only for women and where women themselves are making decisions. And there are other associations that also have some groups for women. For a very long time, and still am a member of the Criminal Lawyers Association, which is one of the most important associations in Ontario for criminal defense lawyers. I mean, you have to join the Criminal Lawyers Association if you're a criminal defense lawyer in Ontario. And they do have a women's committee as well. But Wicked is a bit different because, first of all, it's national, so it's wider in scope. It's not just for Ontario. CLA is really more for Ontario, although I think members from other jurisdictions can join, but it is really an Ontario association. Wicked is a national association. We have members from all over Canada and from different provinces and jurisdictions. And it's only for women, and the decisions are being made by women. And it is also a place that gives a safe space for women to voice their concerns and raise the issues that they're dealing with. Sometimes we notice that a lot of women have issues, but they didn't feel comfortable writing about them in other listservs, not because, nothing against the association, but just because they just didn't feel comfortable. Like sometimes there are some very typical women issues that you only feel comfortable raising if you're a woman. And so with Wicked, we don't have that concern on the Wicked listserv, for example, where we can just talk about these things and without feeling any kind of I wouldn't say fear, but like judgment or concern about writing about these issues. So it is for that. It really helped a lot. A lot of members have actually said that they were thinking of leaving the practice of criminal defense, but Wicked saved them and made them want to stay because they felt that they had this sense of community and strong association. So I'm really happy. Like when I hear these comments, it really makes me very happy and proud of the work we've been doing for Wicked. One of the things that I have been doing personally for Wicked are these series that you've mentioned. There's Finding Your Niche and Who Cares more recently. So it's really very in its baby stages, Who Cares? But Finding Your Niche, we've had a few episodes now. They're all on YouTube. You don't have to be a Wicked member to view these videos. They're open to the public. But what we do in Finding Your Niche is every week we have an interview with a female criminal defense lawyer from all years of call. Like it's really not just for senior or for junior, it's for everyone. And it gives every week a female criminal defense lawyer the opportunity to talk about her practice, whatever it is that she wants to talk about and share with the rest of the membership and whoever is viewing the video. And it really puts the spotlight on these female criminal defense lawyers, and it allows us to see that there are really some very amazing female criminal defense lawyers in our bar. I mean, I just, from doing all these interviews with many of these colleagues of mine, first of all, I got to know them a lot more because many of them, I only see them in court or I only interact with them, let's say for work purposes when we work on committees. But many of them, I didn't even know their backgrounds, the stories that they had. So for me, it was a very interesting, and it still is a very interesting learning experience about, all my colleagues. And I've just realized that there are so many that even though I already admire them, I admire them even more after knowing what they went through, what their past was about. And it just shows how different lawyers have different styles. They have different things that they can bring into the profession. Not everyone will do the same thing. And we all have, like we're all adding something to the profession in a different way, in our own way and our unique styles. And I just, for me, it's been fun. I enjoy doing these interviews. I just love when I get to hear my colleagues and I just put the spotlight on them and I let them tell their stories. And I hope that this is what the viewers are also getting out of these series, and that they're realizing that there are so many amazing criminal defense lawyers, female criminal defense lawyers in this country, and some of them are not necessarily getting the chances that they should be. And I hope that with this series, I am giving them, a platform, a voice, a way to express themselves and to show the work that they're doing. Who Cares is a different type of series. It's more, so we don't just interview female criminal defense lawyers. It's actually open to anyone. And it's more about some interesting issues. Could be essentially legal issues or any interesting issues that we find that we in general are interested in. So we've only had 2 episodes so far. The first one was a little bit similar to what you've been doing on your channel. It was an interview with 2 of the candidates, now benchers, Neha Chugh and Gerald Chan. And it was at the time that we were having the Law Society of Ontario elections. And so everybody was talking about that, a lot of confusion. Some people didn't know what was going on. And so I just decided to interview 2 of the candidates just so they can tell us about their views. And then the second episode that we have out was with Mark Garrigus, who is the most high profile criminal defense lawyer. I could say in the US and maybe in North America. He's very famous. I'm a huge fan of his. And so I was very happy to interview him. I mean, I can probably say I was super excited during the interview because for me, I just couldn't believe I was interviewing, my hero. So that was, like the second episode, and hopefully we have more that will be coming out soon. And it's just about a variety of interesting issues.
Yeah, and I guess the question now, I mean, as we're getting to wrap up here, what's it like being on the other side, right? I mean, I always find when I talk to people that have other podcasts and things like that, it's completely different now when you're like in the spotlight, when you're used to asking questions. So what has it been like there? Now you're kind of in the line of fire. How does that help you relate now to when you go back and do your next episode of Finding Your Niche, when you're asking questions? What is it like being on the other side of the equation?
Yeah, I mean, that's a good question because honestly, I mean, I feel more comfortable being the interviewer, having, been doing all these interviews. I will have to say, I was a bit nervous, but it's honestly, I'm just very, grateful for this interview because it's first of all, it's very lovely to chat with you. I think an interview, what makes it a good or bad interview is also the level of comfort that you feel with the person who's interviewing you. I hope my guests feel comfortable when I interview them, but I certainly felt comfortable today being interviewed by you, and that's why I was very happy to do that. And I also enjoy the fact that you're doing this because you also want to provide this as a learning opportunity for your students. And I really admire and respect anyone who does anything to help other people. And I know you're doing this for free. You're not charging anyone for anything. So this is a very important thing, I think, especially now after the pandemic, because we don't have that many resources as we used to before the pandemic. There were a lot more events, a lot more in-person interactions, a lot more opportunities for people to get to know each other and to learn from each other. We don't have that much right now, but on the other hand, social media and the internet is kind of compensating. So the fact that you're putting out this content and you told me that it was for your students, I mean, I can't say no when it's to help other people, right? Like this is something that you do. It's something that we have in common that I enjoy doing. And just because of that, I'm like, I'll do it because it's, like you're someone who makes your guest feel comfortable, and it's also to help other people. And I hope this interview will help in a way.
Yeah, definitely. I mean, whether it's from the sort of beginning there where we kind of covered the whole process, I think it's a great summary, going from beginning to end, and certainly looking at it in terms of practice and the work you're doing with Wicked and people that can get more information and join and certainly watch some of the Finding Your Niche and the couple of episodes there of Who Cares and the more that are going to come. I mean, I know you're also involved with the CLA on the
Yeah.
recent call committee there. So maybe the last couple of questions here. For those looking to get into the practice of criminal law, whether women, whether recent calls, whether those in school or even just thinking about law school at this point, what words of wisdom, what advice do you have for them as they look to make those next steps in taking this journey into becoming, whether it's criminal defense lawyers one day or somehow involved with the legal system?
So one thing I can say, based on if I look back at my experience and what I had to learn, I would say the number one thing, especially if you want to get into criminal law, you have to have an interest in this area. It's very difficult to do criminal law, whether you want to become a crown or a defense, if you have zero interest in criminal law. It's a very unique area of practice. It can be very challenging. Even when you love it and you get more comfortable doing it, there's always something that you're going to learn. You're never going to know it all in criminal law. It's very challenging. It can be tough. Some cases are really very difficult. You get to know a lot of intimate and very personal information about people. If you're not comfortable with this type of work, then you shouldn't get into criminal law. So the first thing is you have to, if you're thinking of getting into criminal law, you have to have that interest. For me personally, I can say I always wanted to be a criminal lawyer. I mean, the only reason why I went to law school was because I wanted to become a criminal lawyer. I had zero interest in real estate, tax law. I just didn't care. I honestly used to fall asleep in these classes. The only class I was interested, no, seriously, I mean, I was watching Tom and Jerry's in many of my civil law cases. I couldn't care about them. I just only cared about criminal law, and I knew this is what I wanted to do. And if I wasn't going to become a criminal lawyer, then I wasn't going to become a lawyer. I didn't care about being a lawyer. So really, for criminal law in particular, there has to be an interest in it. I would say it's very difficult to survive if you're not interested in this type of work. But then beyond the interest, there has to be also this, you have to believe in yourself. It's a tough environment, especially if you're a female. I would say it's a tough environment because it's still very male dominated. You are going to be hearing from a lot of people who will discourage you, who will tell you, like, well, why don't you do something else? Why don't you go to the Crown's office? Why don't you do family law? I had a lot of people who told me, why are you doing criminal? You don't even look like a criminal lawyer. I mean, many of my colleagues used to be mistaken for interpreters or or for a student, but they were at least mistaken for someone who was related to the criminal justice system. But for me, it was like, what are you doing here? It's like, you shouldn't, like, are you, like, they wouldn't even think that I was a student, or it's like, what are you doing here? Like, you don't belong to this world. And you just have to, trust in yourself. If this is what you want to do, you have to really know yourself, trust yourself, and just keep on doing it. I mean, it's hard. I mean, it's still hard. It's not like it gets easier. And I find like the more you do it, the more difficult it becomes because the challenges become bigger. But you have to, keep on doing it. And, like it's, if you stick to it, it's a very interesting, I find it a very fascinating area of law. I mean, I couldn't do anything other than criminal. And I keep saying, if I don't do criminal, it's going to be something that is completely unrelated to the law. Have zero interest in being involved in the legal justice system if it's not on the criminal side.
We can always keep doing podcasts and interviews and things like that. But I guess related to that, the last thing there for people who go through those situations, right? And of course, you have Wicked now that it is there as mentorship and support. But where you are mistaken as the interpreter, they say you don't belong, because I mean you do belong, right? How do you any advice for women that are in criminal defense there or going through those steps to kind of overcome that? Because again, as you were telling us before, that people were leaving the profession, they felt that their voices were not being heard. And maybe it's something you've heard from all your guests, on finding your niche, or from your own experience. But what can you say specifically to encourage that doesn't continue to happen, and that there are those mentorship and supports in organizations like Wicked, in Senior Defense Council and Junior Defense Council that are there to provide that guidance and help?
Yeah, I think one of the most important things is to reach out, and to take advantage of these resources that are available, and talk to other people who have similar experiences or who you would like to, be like, and talk to them so they can share their experiences. Wicked or the CLA or any other association. There are other associations. These are not the only two associations in Ontario. I mean, there's also the Ontario Bar Association. There's the Canadian Bar Association. They're related, from my understanding. So there are lots of associations. Find one that you can relate to, that you feel comfortable joining. Some of them are free. Wicked is completely free. Others you have to pay. Find one that is affordable, and join it and connect with people. I find it's very important to connect with other people, talk to them. You'll see that many of the senior lawyers who are now, they seem to be doing well. They also had a phase at the beginning where it was very difficult. It didn't go well. And some of them at some point maybe wanted to quit the practice of law. But when you talk to other people who are more senior, who have been through these phases, and they tell you, I know what it's like, I know it's difficult at the beginning, but keep doing what you're doing and it will go well. For me, it's very inspiring and it's very encouraging, because it makes me realize that, okay, so what is happening to me is normal, it's something, it's not just me. I find like often people tend to have that feeling that whatever is happening to them only happens to them and it didn't happen to other people. But when you talk to other people, you hear about their experiences, you realize that, okay, it's normal. That's part of the process. If I just keep doing what I'm doing and I do it well, things will get better. I honestly believe that if you keep doing your best, good things have to happen, like hopefully it will be in defense work. If it's not, then it will be somewhere else. But I mean, I'm still, doing my best so I can keep doing what I love doing, which is criminal defense law. So just, connect, listen to what other people, to their stories. I hope with the series, Finding Your Niche, you're getting to hear a little bit about other people's experiences. You get to see that whatever it is that you have to deal with, like is something that is not unique to you. It's like something that a lot of people also had to deal with, and they found a way. They were able to either deal with it, maybe they're dealing with it now still, but they're also going through the same thing. And once you realize that whatever difficult time you're having is not just you, it's not just, you being punished on your own for whatever, then I find it makes it easier to carry on. And it gives you some kind of hope that you're seeing that someone who went through this was able to survive and they're doing well. So that gives me hope when I see that.
Perfect. So thank you so much once again for taking the time and joining us and sharing about all the amazing things you're doing, the great background there for those kind of the criminal 101 piece there. And again, I think probably the best way is share the links rather than you. I mean, you can certainly explain, tell everyone, your socials there so anyone can kind of follow Wicked and Finding Your Niche. And once again, thanks for taking the time and joining us here today.
Thank you so much for inviting me. It was my pleasure to chat with you today and to get to know you a bit more. And yes, you can find Wicked. Wicked has a link tree, also link where you can find all the socials, and we're pretty much present everywhere on YouTube, Twitter, Instagram. I think we have a LinkedIn account, but you can find that on Linktree. And CLA, it's the same thing. It's also very good. And that's not just for female lawyers, it's for female and male lawyers. And it also has its own socials, Twitter, Instagram. There is, I think, a YouTube channel as well for the CLA. So we're everywhere on social media. And I hope whoever is not a member that you will consider joining. And for the CLA, you do have to pay, but there is a discount, or there is like a reduced fee for students and articling students. So definitely take advantage of that as well.
Perfect. So once again, thanks so much. And thanks for everyone for tuning in. Take care, everyone.
My pleasure.